It's a good story. I guess not. So anyhow, I'm between the cop and the cop.
Seated. Mr. Geigerich.
Thank you, Your Honor. Before you today on State versus Ronald McCauley, file 26 CR 387. We're here today for an information. It's anticipated by the state of Ohio that the defendant will waive his right to have his case presented to the Lake County Grand Jury and to proceed by a one-count information, and furthermore to enter a plea of guilty to that one count. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce his plea. Thank you.
Mr. Novotny.
Your Honor, that is correct. Before coming into court today, Mr. McCauley and myself went over the waiver of indictment as well as the written plea of guilty form. He displayed an understanding about how the procedure for today will go forthwith and ultimately would like to enter into a change of plea. Thank you.
All right. Mr. McCauley, how old are you?
76.
How far did you go through school?
Did a little bit of college at Ohio State.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed
Your
with
Honor.
it? What?
Okay.
He has.
What?
So he has taken in the last couple of days prescription medications with regard to what, your blood pressure, right?
Blood pressure, cholesterol, stomach, gastritis.
Yes.
Okay.
And then 2 days ago he did have marijuana.
All right. Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of the information that was filed?
Yes.
Any questions about it?
No, sir.
All right. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Ms. Novotny some more, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
Do You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Theft is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, a parole authority could return you to prison for a maximum of 6 months. Do you understand that?
Yes.
Do you understand that if your violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I would sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer? Have you had enough time to talk with Ms. Novotny before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
Not at this time.
Mr. Geigerich, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would show that between October 6, 2025 and October 14, 2025, the defendant deposited 3 altered checks, which were from the city of Eastlake, and the loss, resulting in a loss to the city of Eastlake of $3,950. The checks were found to be counterfeit checks to where they were originally for a construction company but were changed to reflect the defendant. Thank you.
How many checks were there altogether?
3, Your Honor?
How much were they? Weren't there 2 to Willoughby Muni? Or from Willoughby Muni?
We had check number, hold on. Check number 123390 was a fraudulent copy. From the city of Eastlake.
How much?
That was the amount of $4,303.64. No, excuse me, that's incorrect. The original check was for that, and it was cashed in the amount of $975.
Well, how's that?
Because they altered the check, Your Honor.
Wait a minute. There was a check. Were these checks made out to the defendant?
They ended up being made out to the defendant, Your Honor. The original real checks were like permit refunds to Lorenzo Construction and things of that nature. The
Right.
checks were then altered to reflect the defendant.
So a dummy check was made up?
Yes.
Not all,
So
that check was
that the actual check number, there was a real check for it, but it wasn't the one that was cashed. So the second one is 123399. It was made out to the defendant, and that was in the amount of $2,975. $2,975. It was originally a check that was issued to a different individual in the amount of $75, again for a permit refund.
Using that same check number?
That check, yes. So you have check number 92 and 99 of that series, Your Honor. So there are two different permit refunds which were altered to be the amount that caused the loss of the $39.50.
And what about the Willoughby Muni checks? The two $500 ones that I had seen made out to the defendant.
Oh, here we go. When the defendant was speaking with the cops, he talked about an individual who was texting him that led him to do this with the fraudulent checks from Eastlake. There are messages telling the defendant to move the funds into his Chime account and Zelle accounts. In addition to the City of Eastlake checks, he located a fraudulent $500 Willoughby Municipal Court check numbered 049219, and it doesn't look like he said he was going to reach out. I don't know if that ever came to anything with that. That just came up through the investigation into the original checks.
So what did he do with the money, with these checks?
He would make it available to this.
How though? Would he cash the checks? Would he deposit the
Through
checks?
he would deposit them in through his Chime account and Zelle account, make it available.
And then transfer it to somebody?
Yep.
Okay. Who's the somebody?
Aline,
Who's the real somebody?
oh, I don't know.
Why not?
I don't know.
Okay. This is probably just a one-off thing anyway, right? Ms. Novotny, anything to add to the facts?
Nothing to add to the facts, Your Honor.
Mr. McCauley, did you hear what Mr. Geigrich said, that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes, but somebody in the internet did this. I didn't do this intentionally.
Right. I understand exactly what happened, and somebody out there is probably doing the same thing over and over again. It'd be nice to find out there's somebody out there,
I
but...
want to catch him if I could.
What's that?
I'd like to catch him if I can.
Me too. All right, but what is your plea to that charge, theft of felony 5?
Guilty.
All right, Ms. Novotny?
Your Honor, we also have a waiver of indictment.
Oh, yeah. Do you understand that you have the right to have your case presented to the grand jury for them to decide whether to charge you? You understand that?
Yes.
Did you discuss that right with Ms. Novotny?
Yes.
And are you going to waive that right?
Yes.
All right. Good catch, Ms. Novotny.
Absolutely, Your Honor.
You should have told me that 15 minutes ago.
I didn't want to interrupt, Your Honor.
Oh, okay. All right. It's going to be a banner day here.
Your Honor, in open court, myself and my client signed the waiver of indictment, passed the prosecutor, witness the same.
Thank you.
And then I need you to sign here and date. Today's date is 8/5/26.
Approach.
Sure.
And then your signature right there. Your Honor, myself and my client signed the written plea of guilty and passed the prosecutor, witness the same.
Thank you.
All right, I'll accept the waiver of indictment. Mr. McCauley, is this your signature on this written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present with counsel, advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I'll accept the plea of guilty. Find him guilty of theft of felony 5. I'll refer this for a pre-sentence report. Sentencing will be September 16 at 1:30. What's the bond right now?
Bond is currently set at $3,500, cash surety 10%.
All right, let's continue.
No,
He posts.
he posted on 3/16 of
Right.
26. Your Honor.
Let's continue.
Or was
All
it
right.
all? Yeah.
You're going to go over to probation.
Yep.
And between now and September 16th, knock off the marijuana, okay?
Yes, sir.
Anything else?
Nothing else, Your Honor. Thank you.
All rise.